Good afternoon or good morning for our Mountain Time attendees. This is Beth Overman with the State Bar of South Dakota. I just wanted to let you know that today's presentation will last between 40 and 50 minutes, and there'll be time at the end for Q&A. If you would like to submit a question, you will have the ability to do so in writing. So you can look at the questions tab on the dashboard of GoToWebinar, and that is where we will collect the questions, and then we will ask them at the end of today's presentation. And with that, I will turn it over to Nicole Tupman.
Hey everyone, thanks for joining us. My name's Nicole. I'm the chair of the in-house committee. I'm a practicing lawyer with Midco here in Sioux Falls. And this is a topic that's near and dear to my heart, and I know to a lot of the other in-house lawyers and other lawyers joining us today. South Dakota is becoming more of a hot seat for technology, and so with that comes all the IP issues. And so we've got some great presenters today, and I'm going to give some brief remarks and turn it right over to them so they can get into the meat. We have Dermot Horgan's knowledge of trademark, trade dress, trade identity, trade secret, and copyright law is deep. His skill set extends to U.S. and international practice. Note his bio on the screen. Ryan Fargan, although he's from South Dakota, he went to the University of Kansas Law School. We won't hold that too much against him. He works out of the Sioux Falls office. His background is in engineering, and he is registered to practice before the U.S. Patent and Trademark Office. Pradeep has been a South Dakota resident for over 20 years, and he also works out of the Sioux Falls office. His background is also in engineering, and he is registered to practice before the U.S. Patent and Trademark Office. So thank you, gentlemen, for joining us. I am really looking forward to this webinar, and I will be quiet and let you all get into the good specifics here. Thank you.
Well, thank you very much indeed, Nicole, and thank you very much indeed, Beth, for inviting us here today, and thank you for the in-house attorney subcommittee and the State Bar Association of South Dakota. My name is Dermot Horgan. I'm with IP Horgan, and we have an office right here in Sioux Falls on Phillips Avenue. We are an IP-only law firm. That means if you need advice about setting up a trust in South Dakota or in the Cayman Islands, we cannot help you with that. We will turn those over to you guys. But if you need assistance getting a patent before the United States Patent Office or a trademark in the Cayman Islands, we can help you with that. The attorneys in our office, Ryan and Pradeep, along with Jamie Rounds, these are guys who live in the area and in most instances grew up in the area. Both Pradeep and Ryan were practicing engineers who have science backgrounds and subsequently became attorneys. So they're a very unusual species. And through them, it is our goal to bring world-class intellectual property services to businesses here in Sioux Falls and in South Dakota and in the area generally. So for today's presentation, we're going to provide an IP primer. We're going to look a little bit at patents, you know, what type of matter is patentable, and look at the process of getting a patent. From that, we'll transition to talking about trademarks. We'll discuss a little bit about what a trademark is, how you acquire the rights, the importance of getting those rights. And then at the end, we'll pivot to copyright law. We're going to focus specifically on music copyrights, but we'll also talk a little bit about photographs and other types of copyrightable material. So with that, I'm going to turn over to Ryan Fargan and Pradeep Jaraman to lead off with the patent section. Gentlemen.
Thank you, Dermot, and thank you all for attending. You guys are quite the diverse group, and you spend most of your days just putting out fires, so we're trying to help you avoid some of those fires and give you some details that it can actually help you going forward. So as Dermot said, Pradeep and I are both registered patent attorneys, so we're gonna get you going on that. So the first thing is, you know, what is a patent? And for those of you who don't know, it's a property right you get from the United States Patent and Trademark Office. It is something that lets you exclude others from doing things. They can't use, make, sell, or import your invention into the United States. Basically, you're given this because you are teaching society a new, useful invention and moving technology forward. And so in exchange for that, you get a limited monopoly. So there are three major types. The first of which, there's three: utility, design, and plant patents. The first is utility. Utility primarily covers the function, and it's for new and useful inventions. Its duration is for 20 years from the non-provisional filing date. And the reason we have to say non-provisional is you guys may be aware of provisional applications. They're a little less structured application, but they're really great, and they can help you win the race. That's how they're usually used. So if you're worried about somebody filing before you, they can be a great avenue. They do require that you file a non-provisional within 12 months. And so you can take that time to kind of refine how you want your claims to be or parts of your application. But you need to understand that you're limited by the total scope of your non-provisional. So you can't, or of your provisional. You can't claim anything new. No new material can be claimed in your non-provisional that wasn't there. So if you have like an improvement and you didn't exactly maybe get the words right in your provisional, one way you can try to show that it was there is drawings. So we would always encourage people for a provisional application, drawings can be your best friend because, you know, the old adage of a picture can be worth 1,000 words. So another thing we'd like to address when filing your applications, it's an important time to evaluate if you have any interest in international protection for a patent. So through the Patent Cooperation Treaty, created the PCT applications. So you can file with the USPTO locally, but if you do a PCT application, you can actually save your spot internationally, and you can delay both what countries and some of the costs associated with filing in those foreign countries by up to 30 months. So you can kind of say, yeah, I think we're going to do it, but you got a little bit of time to decide. And then some of those costs, you know, the actual filing costs and also translations. So foreign countries might have translation requirements that you have to do as well. So those things can all be very expensive. So you can actually push that a little bit. Otherwise, if you're not going to go that route, but you want to go internationally, you need to file pretty much at the same time as locally, because otherwise you run the risk of being prior art against yourself, which we'll kind of discuss later. Right now, Pradeep's going to kind of discuss design and plant patents. Pradeep.
Thank you, Ryan. The second type of patents that there are the design patents. They protect the visual ornamental characteristics of an invention. You folks have heard the saying, form follows function. A utility patent protects the function of the invention, and the design patent protects the form of the invention. These are granted for 15 years from the date of from the application date, and an application for a design patent contains one claim for the whole design. So we get to explain everything that we want to claim about the design in one sentence. Further, it makes common sense that the subject of a design patent cannot be offensive to a race, religion, gender, ethnic group, nationality, etc., because, you know, it just makes sense. The third type of patents is plant patents, where plants can be patented if they are grown in a cultivated state and asexually reproduced. By that definition, it excludes tubers like potatoes, sweet potatoes, yams, things like that normally grow by asexual reproduction. These are granted for 20 years from the date of the application. And again, like in a design patent, we get to write one claim to claim the whole plant instead of a part of a plant like a fruit or a flower or something like that. The three things to watch out for a plant application are in a cultivated state, asexually reproduced, and excludes tubers. Now moving on, it's a very important question that what kinds of subject matters are eligible to be patented. And the law says that any new and useful machine, manufacture, process, or composition are eligible to be patented. Now, in this example, in the slide in front of you, we have a tire. A tire is a manufacturer, which means it is the end product. It is the stuff that is made by a process or a method, and the tire itself is eligible to be patented. There are machines that were used to make the tire, and the machines are also eligible. The process or the method that was used by the manufacturing company to make the tire is eligible to be patented. And last but definitely not the least, the composition, the stuff that makes up the tire, the rubber, the sulfur, and all the other things that go into making the tire, the formula or the composition is also eligible subject matter. It's also noteworthy that an improvement of an existing invention is also patent eligible, and the new use for something that was already existing is also patent eligible. Now, we saw that there are 4 things that are patent eligible. There are 3 judicially created exceptions that are not patent eligible, and they are laws of nature, natural phenomenon, and abstract ideas. For example, gravity. Gravity exists whether we observe it or not. The earth revolves around the sun whether we observe it or not. And we have 4 other examples over here on this slide to illustrate the point. The first one of them is DNA. DNA and genetic material make up every living thing, and whether they are discovered or not, doesn't matter, they exist. So they are natural phenomena, therefore they are ineligible to be patented. The second example is wind. Wind is a natural phenomenon as well. Now, the windmill that uses the wind energy to create electricity could be patentable or patent eligible, but the wind itself is not. The third example is the Pythagoras theorem that actually my children taught me recently. And that is just a law of nature that exists. That is the relationship between the sides of the triangle, whether we know it or not. Therefore, it is not patent eligible. And lastly, and interestingly, clones. A clone, by definition, has the same genetic material as the donor organism, and therefore, Dolly, the sheep that was cloned from another sheep, is not patent eligible. Now, there is a little strange story. I'm going to advertise my geekness over here. In Star Wars, as you are already aware, the Kaminoans cloned Jango Fett to create the clones. In exchange, he wanted one unaltered clone, aka Boba Fett. Now, Boba Fett has the same genetic material as Jango. So in the real world, he would not be patent eligible, but the clones were changed to grow and mature faster. So they are potentially eligible subject to get a patent on. Back to you, Ryan.
All right, sorry. Thanks, Pradeep. So Pradeep kind of covered what is patentable. And so now the next term that we're going to discuss is prior art, which is how you know what has been disclosed or what's already known. So prior art's the term used to describe what's already been taught to the world. So obviously you can't get a patent for something that has already been taught, and even if you taught it in certain cases. So if you did teach it and you disclose, you should know that you start the clock. And we're going to use that clock term because in the United States, you're given a 1-year grace period from a disclosure of your own disclosure to cure that by filing a non-provisional application. So there's 3 major categories of prior art: patented or described in printed publication. And that one's pretty straightforward. I mean, you need to know what's been patented and published. The thing you do need to understand, though, is that this is worldwide and in any language. So if it's a book on a dusty shelf in a foreign library in a foreign language that's never been checked out, it's still a printed publication. You may not be able to find it, but it will count against you if somebody else does. So knowing what's disclosed early can really help you adjust where you need to be if you need to pivot into a different area that there's less competition in or that's been less disclosed. And so generally we would recommend something like a patentability opinion, or you can do even a prior art search to kind of figure out what's out there or where you might be. And now the second one is in public use or on sale. And so this includes testing your invention out in public. I mean, and it also includes offers to sell. And so of that subject matter. So our advice is always to keep it secret, but that might not always be possible as far as the public use. So you can get away from a public use being a disclosure if it's kind of required. You know, it's if you're designing planes or big equipment, it may not be reasonable to expect you to do only testing in a computer or a wind tunnel or stuff like that. You may have to take it out into the real world, but taking the appropriate steps like testing it at night or in remote locations or covering up whatever is your really important information so that somebody can see it but not learn from it, that can help you prevent a disclosure and not start the clock. So it's something you need to kind of coach your R&D people or anybody that's working on inventions, you know, hey, if you have to test it, fine, but do it as secretly as you can. And if you think you might be disclosing, you know, you might want to do some more documentation. Now the sales, even if they're private, can be a disclosure. It's hard to find that, obviously, but if it comes up, it can be a problem. So you really do need to kind of coach some of your salespeople the risks of trying to gauge the market by reaching out to their sales contacts. That can be a really risky thing to do. So everybody wants to talk, everybody wants to disclose, but you really need to rein that in or at least try to get it, you know, make them wait until the patent application happens. Now, the last thing, which is almost the scariest of all three, is otherwise available to the public. This covers almost, I mean, does the public know about it? Yeah, okay, so it might be disclosed. Now, for in-house counsel, things that you might have to tell people not to do, and so is a public social media post of an update or Twitter, things like that. Anything that goes out on social media, anything discussed at a expo or a conference that any of your engineers, developers, or anything like that might go to, anything they're giving to the public could potentially a disclosure. Handouts, printed materials, always a mess. Like just, they're hard to get back. So you gotta assume if they're printed out, they're really hard to get back. But it is important to understand that if somebody else discloses, it starts the clock. Now, if it's your own disclosure or you think that they took it from you, you're gonna have to prove that. And so it's important to know where your sensitive material is, who has access, when they had access, and then keep that. Because if you're working on something for 2 years and then somebody files an application or discloses publicly your invention, but they were an intern for you on month 2 or month 6, you're gonna have to be able to show that, hey, they really kind of took that from us. So the best recommendations to you guys is keep things as secret as possible. We understand it's not always in everybody's best personal interest, but you kind of need to coach everybody to make it their interest on this behalf of the company. So we've kind of now established what you need to know if you want to have if your idea is patentable and if anybody else is kind of blocking you from it. So you might be ready to patent, but you need to understand it's a long process. We break it down into 3 major phases. There's before the filing, so pre-application, and then the examination phase, and then the post-issuance phase. And so as we discussed earlier, you get 20 years, but that starts on that filing date, which is the first day of phase 2. But you won't have a publication for 18 months. So month 0 is the day you file. The next thing to happen is a publication on month 18, but you're not going to have an office action response or hear back from the USPTO for up to 2 years. And this whole thing of getting an application become a patent can be 3 to 4 years, and the 20-year mark is running. So the minute you file, we really want you to understand that it's a race to file, and then before that is what establishes the prior art, that we just mentioned. But the minute you file, your patent pending. So you really should be going forward and taking advantage of the application you've just filed. Now, the goal is to file the best application as fast as possible, but there are some factors you need to be aware of. You know, we like to say it's a race, so you want to finish first, but you got to finish first. And so it's a race. America is a first to file country. So being the first to invent no longer matters. It is the first to file. But like we said, you can't add any new material. So if you file, you're locked into that. So any improvement or an omission would need a new application. And so part of the patent is you disclose. So you've already told the world your invention, and then so immediately you got to assume your competitors are now trying to just focus on improvements. Well, if what you disclosed isn't the best version, you need to beat them to the improvements. And so improvements or omissions, you're going to have to file a new application, which will get a later date, but you do need to react quickly. So it's important to file the best application you can as fast as possible. But if it's highly competitive, file first and then kind of see what you can do from there. This is a little more into the examination deal. This is the arguments that the USPTO is going to kind of bring up with you regarding prior art. So now that you kind of know what prior art is, here's how it gets used against you. We're going to kind of simplify this to kind of get through it. It's really technical, so please, if you have questions, send us an email. It's much easier that way. But anticipation and obviousness are the two core things. The crux of them both is anticipation is, did a single other claim already claim what you are trying to get? And then obviousness is, well, did one or more? Would it have been obvious to make your new adjustment based on what was already known if you're somebody that's in that area? So we use the term FOSITA, a person having ordinary skill in the art. So it's not what a super genius expert tinker, Elon Musk, if he would have thought of it, doesn't really matter. It's somebody that's, you know, a more common person in that field. And so an example we're going to kind of fly through here. I want you to pretend that that triangle is a tricycle. It's just going to be much easier this way. So a tricycle is a seat, a handlebar, a frame, and 3 wheels. Well, if the other thing is a bicycle, it has almost all those, but it doesn't have the 3rd wheel. So if they're not talking about the 3rd wheel, you're not anticipated. So you're going to be fine. Now, a 4-wheel bike or car, whatever you want to call it, might have all the things you're already claiming. So therefore, you've already been anticipated. A 3rd wheel would be included in a 4th wheel. So that's kind of the thing. And so obviousness, the difference here, though, is you're comparing things that you might beat on anticipation, but maybe not in combination. So comparing a unicycle to a cart, well, okay, so now we've got 1 wheel and 4 wheels, and then you throw a bike. That might be obvious. But if you're comparing completely different things, well, some planes have 3 wheels. Well, is that obvious? You know, planes may not be close enough to bikes. And so it's really a discussion on, would somebody that's in that world have thought of your invention if they knew and can combine the understanding of a variety of other inventions? So with that, I'm going to pass it back to Pradeep to discuss some of the recent changes in patent law.
So folks, there have been a couple of recent changes in the patent law that is going to help patent owners more and make it more difficult on patent trolls. As you already know, trolls are cute little colorful cartoon characters. They sing many songs in a DreamWorks movie. But patent trolls are people or companies that acquire patents and make money by suing infringers or attempting to sell that particular patent for a lot more money later on. And usually patent trolls do little to nothing to develop the patent to provide a product or a service. Now, the first case is TC Heartland LLC versus Kraft Foods. Now, prior to this decision, the venue for a patent infringement suit could be anywhere where a court could exercise personal jurisdiction over the defendant. So that encouraged patent trolls to forum shop. And at one point in time, the US District Court for the Eastern District of Texas became the venue for a vast majority of infringement suits. They were very plaintiff friendly, and so that is the reason for choosing that particular court. However, the TC Heartland decision reduced the venue to two possibilities: where the defendant is incorporated or where the defendant may have committed the act of infringement. So patent trolls are not able to forum shop anymore, and so they are restricted in the venue where they can bring the suit. The second is when the Patent Trial and Appeals Board adopted the Phillips standard for reviewing claims construction in 2018. Prior to that, the board used a standard that is called as broadest reasonable interpretation, or BRI. Now, as the verbiage indicates, they gave broad meaning to the language of the claim. The Phillips standard, however, from the famous case Phillips versus AWH Corporation decided in 2005, said that the claims are to be given their ordinary and customary meaning. For example, when we look at the phrase reside around, does that mean lying nearby, or does that mean wrapping around or surrounding? Now, under the BRI standard, laying nearby might qualify, but under the Phillips standard, it does not. It's got to be surrounding the other thing. So when the PTAB, or the board, the Patent Trials and Appeals Board, adopted the Phillips standard in 2008, it restricted the ability of patent trolls to invalidate other patents. So the moral of the story is, now with these two improvements in the law, the patents that you own are more secure from patent trolls. So as long as we are talking about patents, just a little bit about a trade secret. A trade secret is something that has actual or potential economic value, sometimes a lot of value. Others cannot obtain this information legitimately, and the owner of the trade secret takes reasonable precautions and efforts to maintain its secrecy. Now, there are some common examples of trade secrets that we already know, which is the formula for Coca-Cola that has been a secret for over 100 years, since the late 1800s, I think. The recipe for the KFC original chicken, Krispy Kreme donuts, Listerine, WD-40, it's a big list. And in many ways, trade secrets are a flip side of patents. You know, when somebody decides to keep it a secret, they don't reveal it, and they keep it a secret, and they take precautions to keep it a secret. But if somebody files for a patent, they have to reveal it to the whole world. Trade secrets can have virtually unlimited protection. Like example, the formula for Coca-Cola that's remained a secret for a long time, and patents always expire at the end of their term. Now, trade secrets also have a disadvantage where if somebody develops the same thing, for example, if I develop the recipe for Coca-Cola in my basement, the Coca-Cola company is going to have some tough time. But if you have a patent, you can stop other people from practicing that invention, which you are unable to do so when you have a trade secret. A recent trend in the trade secret law is the Defend Trade Secrets Act of 2016, where Congress created the ability for a trade secret owner to sue in a federal district court instead of looking for diversity and other rules or going to the state court, and also offered legal immunity to whistleblowers. On that note, we are going to be moving on to the trademark section. Back to you, Ryan.
All right, thanks, Pradeep. Like Pradeep said, we're going to move to trademarks. And so at the core of trademarks is the goal to distinguish competing goods and services. The goal is to identify the source so that consumers don't get confused from my goods or somebody else's. So some examples of trademark use. You have words, vans, or booking. I mean, these are both relatively straightforward. You can also have slogans. Designs, usually used for logos, are kind of a way of using trademark. Here we have the BP logo. 3D shapes, which are kind of configuration marks. Here, the way this looks is what's being protected. You can also do colors. Now, colors can either be a part of your another mark, like your design, or you can actually get a color itself if it's distinctive enough. So as an example is UPS has brown, and then Tiffany & Company, their blue is protected. There are some other uses you can try, the most prevalent to being sound, the NBC chimes, but you can also get things like motion and smell and other things like that. So it might seem obvious, but it's important to understand trademark distinguishes products and service marks distinguish services. Now we're going to kick it to Dermot to discuss distinctiveness.
So one of the critical phases in selecting a mark is you want to pick a mark that is, how should I say, a strong mark, meaning gives you a broad range of protection. A strength in terms of marks is often talked of in two ways. There's marks that are commercially strong, that means they're very successful and very famous, but there are also marks that are inherently strong. So if we can move down to the reason you want to get a strong mark is so that it gives you a broad range of protection, but also so that you can stop others from using it. You also want to pick a mark that's available. Let's look a little bit at strength for a moment. So on this chart, there are on the left-hand side, those marks that are never distinctive, very weak, they're basically unpredictable. These would be generic terms. And on the far end, you've got fanciful terms. These are terms that are made up. Let's take an example. Let's say that there's a coffee store here in Sioux Falls that has developed a successful following for a particular blend of coffee. And they now want to start shipping it nationwide. And as part of that, they want to select a mark. Their options might include, well, coffee beans. Well, coffee beans is a generic term. It simply names the product. And that's a terrible mark. It's unpredictable. Anyone selling coffee can refer to their product as coffee beans. Dropping that, they might say, well, what about ripe red beans? In the context of coffee, that's a descriptive term because it really describes a coffee bean before it's roasted. After it's roasted, it goes brown, but before that, it's red. So ripe red bean would simply describe a coffee bean, a terrible mark. Moving on from that, maybe they could select something like bean blossom. Well, has bean in there, coffee bean, blossom doesn't really mean anything and could kind of suggest, blossoming or growing or something. So, it's what we'd call a suggestive term. And this is protectable because, someone wouldn't obviously think of using a term like bean blossom on it. They could also go for something arbitrary. Let's say they took the word bandwidth. I mean, it's a dictionary word. It has a specific meaning in the context of internet services and various other things, but in the context of coffee, it's completely arbitrary. Or else they could elect to invent a word. Let's say a tocad. That's actually Dakota spelled backwards, but for our purposes, it's an invented word, a tocad. The problem, while lawyers love arbitrary and fanciful terms because they're very easy to protect, I mean, nobody can use bandwidth for coffee without infringing our mark or a tocad. The problem with them is they don't tell you anything about the product. You're going to have to spend a lot of money, a lot of time and effort trying to educate people as to what bandwidth means in the terms of coffee. Whereas a suggestive term like bean blossom is much more likely to be acceptable. So let's say we've settled on bean blossom as our mark. We still need to make sure that we own it, or that at least we've got the capacity to own it. And what that really means is it can't be identical or confusingly similar to someone else's mark that's already out there. Similarity uses two principal criteria. There's similarity of marks, and then in conjunction with that, the similarity of goods and services. So looking at bean blossom, a good starting point would be to take a search on the internet, see what you find, if there are any uses in the context of your goods. If you don't find anything there, maybe you go to the USPTO and run a search. So if you run bean blossom in the USPTO, you're going to find that there are actually two pre-existing registrations. One of them is bean blossom for maternity wear. Well, the marks are identical, which is bad, but the goods are completely unrelated. So I don't think there's any risk of confusion between bean blossom for coffee and bean blossom for maternity wear. So that's not an issue. But there's also a second one, which is bean blossom for hard cider. And this becomes a little more complicated because in considering the similarity of goods, courts and the USPTO kind of have a 7-factor test that they go through. It kind of looks at the goods themselves, looks at the customers, the channels of trade, the conditions of sale. It's a very technical type of test. And the bean blossom selection is not an accident because, you know, superficially you might think hard cider and coffee are completely different, but there was actually a decision on Tuesday of this week that found they were confusingly similar, that bean blossom for hard cider was likely to be confused with bean blossom for coffee. So it's a little bit more nuanced than you might expect. In our instance, the advice would be, well, let's go with delightful blossom. That looks like it's free and clear, and off you go. Back to you, Ryan and Pradeep.
So a question that often comes to our mind is, why should somebody register their mark with the USPTO, and how does it work? Now, if somebody registers the mark, they get to use the symbol, which is the R with the circle around it, which provides notice to everyone that you own the mark. There is a presumption of validity by providing that notice. There is also a presumed right to use it nationwide. So if you have a name of your business over here and somebody decides to open up a similar name across the border in Minnesota, they may not be able to use it because there is the presumed exclusive right to use it all over the United States. It also blocks others from registering a mark. It is an asset. There is a place in the balance sheet of every company that talks about intangible assets, and patents and trademarks are there, part of the intangible asset. They can be used as collaterals for securing loans from banks. And in many countries, they can also be registered with the customs. So importing that trademark in a unsuitable way, in an improper way, can be avoided and watched out for. The second question is, how can one acquire a trademark? And that is through use or through registration. Generally, the earlier of the first to file or the first to use gets the mark. In this particular example, I filed for a trademark on January 1st, 2017. And Ryan starts to use the mark on March 20th of 2020, 3 years later. So in this case, because I use the mark first, I win and I get the trademark. In the next example, Ryan starts using the mark in January of 2020, and I file for the mark in March of 2020. Here, Ryan's use precedes my filing, and therefore Ryan wins. Now, this applies to acquiring trademarks in the United States, but when it comes to filing for them in foreign countries, it's a different ball game, and Dermot will elaborate more on it.
That's right, Pradeep. Once you go abroad, you're suddenly not in South Dakota anymore. So while in the United States, the owner of a trademark is the first to use or to file for it, abroad, rights are acquired more or less exclusively through the process of registration. For instance, a number of years ago, we had an airline client come to us, and I mean, people are well aware of situations in Germany, not Germany rather, but in China, where people have had problems. Michael Jordan, for instance, the name was scooped up and there was a big battle over it, and even Donald Trump spent some time trying to recover the name Trump in China. But it's not just a Chinese problem, it exists everywhere. As I was saying, we had an airline come to us that had been servicing, had flights going into Germany for 15 years, and they had been using a mark in connection with one of their products. They never thought to register it because they felt the mark didn't merit that. But over the course of 15 years, literally hundreds of thousands of people had become exposed to the mark, and it had become very valuable to the airline. However, a German national filed an application for the identical mark, claiming the identical services, and within 48 hours of their registration issuing, got an injunction against our client, prohibiting them from using the mark. So even though our client had been using it for 15 years, there was no question about who was first to the market, and even though they'd exposed literally hundreds of thousands of people to it, this later applicant ended up being the owner of the mark. So the message for you and your companies and your clients is, you know, when you're looking abroad, you've got to think about registration. And acquiring a registration takes time because you've got to clear it and you've got to go through the registration process. So this is really something that you need to be thinking about 2 or 3 years before you ship that first container, because it takes time. So you want to be thinking ahead 2 or 3 years at a minimum to start protecting your marks abroad in particular markets that you're looking to. Wrapping up here, just in terms of recent developments, Ryan made a mention to it at the outset. There was a Supreme Court case within the last month on Booking.com. I think it may have been one of the last reported decisions by Justice Ginsburg. But the issue before the court was whether a generic term like booking could become a trademark just by the addition of a URL or GTLD like .com. The position of the courts and of the Trademark Office for years had been that it couldn't. It was still a generic term, and the addition of .com to it didn't change that. The Supreme Court, and indeed the Court of Appeal, and the District Court beneath it on this case, all took a different position. And they argued and found that really .com refers to a specific location, a specific business. As consumers, we all understand that Booking.com is a reference to a particular entity, a particular source, and for that reason, it should be capable of functioning as a trademark. It may be descriptive, but if it becomes well known through use, there's no reason why it shouldn't become protectable as a trademark. And in the case of Booking.com, that was their ultimate conclusion, that it had become a trademark and was available for registration. So that's kind of the big news of late in terms of trademarks. We're now going to move on to copyright. And today we're going to focus primarily on music, because I think music is actually something that, you know, many of our clients and businesses have some interaction with. They often play music in their stores and their bars, in the common areas of their businesses. Maybe they've got music on hold. So I think it's kind of broadly applicable. And there are copyright issues involved in this that are worth some consideration today. So a copyright subsists in an original work of authorship fixed in any tangible medium of expression. Let's break that down slightly by moving on to the next slide. Originality. This means it's got to be a work of independent creation. It doesn't mean that no one else has ever created something similar to it, but it's got to be original to the author and can't have been copied by the author from someone else. It must also include a modicum of creativity. The courts have kind of found that's very low and could even extend to something resembling a telephone directory. It doesn't have to be a Picasso to meet it. There's got to be authorship. It's got to be something that's created by a person. It can't be created by a machine, or it can't be created by a monkey. There was a famous case recently where a monkey took a photograph, grabbed a camera and took a photograph, and there was a big dispute over who owned the copyright in that, and I'm afraid the monkey lost out on that. And then copyright itself applies to the expression of the idea, not the idea. So for instance, if I tell Pradeep that, you know, I've got this great idea for a book that I'm thinking of writing about how a great white shark marauds seacoast towns along the east coast of the United States, and I'm going to have the local sheriff team up with a salty dog, and they're going to go out and kill the shark. What do you think? You know, I explain all of this to Pradeep. There's no copyright in that. I haven't reduced it to a tangible form. It's not in writing. I haven't recorded it. I haven't saved it on tape. There's nothing. Only when I commit it to paper or commit it to some sort of a tangible form is there a copyright. And then that copyright extends to the expression of it. It doesn't cover the idea. For instance, if I wrote a book on how to do a surgical operation, which would be a terrible idea because I'm a lawyer, not a doctor, but let's say I wrote a book on how to perform a certain operation. The text of that book would be protectable, but not the details of how to perform the operation. Any doctor in the US could still use that idea and that method for performing the operation. My copyright in the book isn't going to make any difference to that. Moving on. We're now going to talk a little bit more specifically about how these concepts of copyright apply to music. We're all familiar with recorded music. You know, a few years ago, we probably all had lots of CDs. We probably don't have them so much today. But, you know, let's talk about the CD a little bit because the concepts are broadly applicable. In a CD, there are two specific forms of copyright that we need to be concerned with. There's the musical composition. That's, you know, whoever sat down and actually wrote out the dots and quavers and what have you for the music. And then there's actually the performance by the musicians. That's the recording. The two of those are separate copyrights. And the rights that the owners of those have kind of include the right to reproduce. That's to make copies of those recordings or of the work. To make derivative works, in the case of the owners of the composition, that's to decide who gets to make recordings and maybe to make changes to the recordings and things of that nature. It includes the right to distribute. That's make copies and hand them out to each of you. That's a right that's reserved. And to perform. Let's talk a little bit about perform. When I buy a CD, or let's say I get a Spotify subscription or Apple Music subscription, that subscription really licenses me to use the music for my personal enjoyment. I can play it in my kitchen, I can play it in my dining room, I can play it for my family, I can play it in the car. I can't take it and play it for all of you guys. That's outside the scope of the thing. If I'm to play it in a public area, now I need a public performance license from, and I said there were two copyrights. I need one from the owners of the rights in the composition. Curiously, I don't actually need it from the artists. For years ago, the radio industry managed to convince Congress that there was no need to reward the artists for their performance because they'd be rewarded through the sales of records. It's all changed now, obviously, but that's the way it goes. But there is a performance right in the composition. And if I'm going to, play it in public, I need to get a license to cover that. You've probably all heard of the performance rights associations. They are bodies like ASCAP and BMI. The two of those essentially cover most of the US rights owners. And there's also a third one called CSAC. And typically they represent more overseas copyright owners, not so much those in the US. But for our purposes, you need to be aware that if you're going to be using music in public, so if your clients or your business is playing music in the lobby or in a bar or in the restaurant, that's a public performance and you need to get a license. They're not hugely expensive, but you need to get them. And if you don't, someone like ASCAP or BMI, to paraphrase the song, those guys get around and they will get to you at some point. So we've pretty much used up our time at this stage for the formal part of the presentation. I want to leave a little bit of time for questions at the end. But maybe we could go to the summation slide, Ryan, where we have a single product. So here is a single item, and it kind of shows you how all 3 species of intellectual property can actually reside in the same item. There could be a utility patent, as in the case of this Vans shoe that has a removable vamp. That's the piece that you see uplifted there. And what it does, I guess, is it allows the owner of these shoes to change their personality day to day. There could potentially be a copyright, and indeed some of the Vans patterns are copyrighted. Not the checkerboard that you're looking at, that's kind of a very standard type pattern, but if there were some other flourishes through it, the pattern on the fabric would be amenable to copyright. The name Vans and its flying V that you see there, that's a trademark for that. The shape of the shoe could potentially be a 3-dimensional trademark, and what's referred to on the right-hand side here as the waffle sole. That's got, if you look at it closely, it's got a curious arrangement of patterns, and that is actually the subject of a US registered trademark. So those are the various ways of intellectual property and how they can fit together in one product. I should mention, you saw Ryan skip through it, we do have a bunch of scenarios on the music towards the end of our presentation. We're happy to share those with you. You can have a look at the scenarios and we'll be happy to give you the answers. They're kind of brain teasers in terms of performance licenses. So I think that kind of wraps up the formal part of the presentation for this afternoon.
And this is Nicole. Yeah, thank you. Ryan, did you have anything else to present? Otherwise, we'll take any questions that we have. Looks like there aren't any in the chat box, so I have a couple.
Okay.
So this is my favorite, one of my favorite things as in-house counsel to get to do is we have somebody who's very creative and has created, you know, a great PowerPoint and used all kinds of copyrighted images and music and videos. It's going to be for internal presentation only. But how do you handle that situation? And you have tips and tricks for educating our business people on how to use copyrights appropriately.
So I'll take that one. I think first and foremost, you need to understand that anything internal is no longer internal in terms of today's business. You know, everything gets shared and everything gets talked about, and people move on and talk about the presentations they saw internally. And sometimes, you know, people, you know, that will, for whatever reason, turn you in. So you have to be very careful about your use of copyrights, even if it's purely internal. The second thing is you can't just go out and grab images and stuff from the internet. I'm afraid this is where the lawyers have to be spoilers. Most of these images are subject to copyright and very often they're enforced. I can tell you that many clients we deal with end up getting letters from the like of Getty Images on a regular basis relating to images and stuff that they use on their website, which are actually subject to copyright protection, and people like Getty will go out there and do it and chase you down and charge you thousands of dollars for the use of these images. There are a few sites that offer royalty-free licenses for commercial and personal use. In fact, many of the images that you saw in today's presentation came from some of those. Shutterstock has something. There's a number of others that are in a similar vein. But you have to be wary because it's not always clear how complete their rights are. I mean, you take it on faith, they say they have the right to give it to you, but that's not always the case. So it's very difficult to clear the use of copyright owner images unless you can positively identify the owner of the rights and get a license. And you know, one source for getting even paid licenses would be someone like Getty Images. You could go through their library and pick out some images you want and pay for them. With using music and certainly using video, you've exactly the same issue. You can, you know, there are lots and lots of troll lawyers, and Pradeep made a mention to troll lawyers, and these are people who basically are in the business of going out, finding infringers and suing them on a contingency basis on behalf of rights holders. It's a big business, and in copyright law, you need to be aware there's something called statutory damages, which means you can claim damages without actually showing any losses. And for copyrights, they start at $750, but they go up to $30,000 per use. And if the use is willful, if they determine that you deliberately took this and decided it's only internal, nobody's ever going to find out, they can be increased 5-fold. So that 30,000 could end up costing you $150,000, plus there can be attorney's fees. So you have to be careful. And this is big business. There's, like I said, there's lots of troll lawyers out there chasing this one. We heard of one recently. Actually, there was a pay-per-view thing. That was it was a medical conference. There was some pay-per-view boxing match on, and a bunch of doctors were at this medical conference, and they all piled into this bedroom to watch the show. What happened was one of the hotel employees actually turned them in and reported them, and they ended up getting sued for copyright infringement. I think there's probably 2 lessons to this one. One, if you're going to be using a pay-per-view in public, get a public license. But maybe the more important lesson here is don't stiff room service.
That is some creative lawyering there. That's I haven't heard of that one. Thanks for that, and thanks for the overview. I think it just gets, we get these creative folks and they just want to make their PowerPoints pop. And so thank you for the reminder on our jobs to get after them.
Yeah, I mean, the solution really is to take your own photographs. Then you're free and clear. That's really the safest way. But there are organizations like the Copyright Clearance House, but they're not really clearance organizations either. They're licensing organizations. What you'll find is they have a bunch of authors who subscribe to their service, and so you can get a license through them. That's the clearance they're providing. So their members will give a license, but it's very tricky.
And I've got maybe just one more question to wrap up is, what do you suggest, for those of us who have, are creating internal works and sharing them internally, when should we use a copyright? How often on internal communication should we use our trademarks and our copyrights, or, service marks, things like that? Is there a best practice? Because sometimes you see so many of the marks on an internal communication, it gets messy. Is there some good guidance
it does.
there?
Yeah, so really the solution here is for the trademarks, it should be on the first most prominent use. So, if you have the trademark at the top of the page, maybe there's a banner up there that features the mark. Maybe it's the house mark, or maybe it's the product mark. You can identify that using the registration symbol or the TM symbol. And then through the rest of the presentation, you don't need to do that. However, you should make the mark stand out in some fashion. Use it in block print, or use it in some sort of stylized print. Just make it clear that even though you're not going to use these cumbersome symbols, that you're still referring to the mark as a mark and not as a descriptive term or as a name for the thing. And then for the copyright, depending upon what it is, the copyright exists automatically. The minute you create it, the copyright exists. So you don't have to necessarily identify it as copyright, 2020, all rights reserved. That's a best practice, but you don't need to do it. The copyright exists automatically. But if it is something that you're taking particular pride in and you want to kind of warn people off, maybe it's a brochure, or maybe it's a flyer or whatever, in those circumstances, maybe it's worthwhile including your reservation, copyright Midco 2020, all rights reserved.
Helpful. That is a helpful one. Well, I don't see any other questions in here, and I know we're at time, but I just want to thank you all. This was wonderful. I wish you had been my professors in law school. I probably would have taken a lot more away from IP. But I encourage those of you who are on the phone from the committee, these gentlemen are well versed. This is a firm that is dedicated to this. So if you have questions, I know they're happy to answer them, and the slides are available. You can download them on the handouts here if you see it on your webinar, and kind of run through those scenarios, because I found those pretty interesting. So thank you. Thank you very much, everyone. Thank you, IP Horgan, for presenting today. We really appreciate it.
Thank you.
Thank you, guys.
All right, thank you, Nicole. And on behalf of the State Bar of South Dakota, thank you everyone for joining us, and we hope you have a great rest of your day. Just one thing to keep in mind is after today's webinar, you'll receive a survey on the presentation, and we'd appreciate for you to complete that and provide us our feedback for future programming. Have a great rest of your week, everyone.